Okay, good morning, everybody. My name is Robert Sheldon. I'm the Vice Chairman of the South Florida AILA Litigation Committee, and we want to welcome you to our webinar today on suing the government under the Federal Tort Claims Act and Bivens. We have a short video I'm just going to play at the very beginning just to show what we're dealing with.
Wait a minute. You're filming me. You're impeding me. What are you doing? Can you tell? Okay, hold on a second. I need to ask your citizenship. Come here. State your citizenship. Let's get a citizenship. No. I refuse to answer any questions. I refuse to answer any questions. Come here. I have to ask you to come with me. You're under arrest.
Okay, like I said, that was pretty short, but that gives an idea why we need to do this. This guy was just videotaping some CBP officers and not doing anything wrong, and then he was arrested and threatened with 20 years in jail. And if he hadn't had that video showing that he didn't do anything wrong, he might have actually gone to jail. So that gives an idea. Our system usually seems like it's pretty biased against our clients. We have all these jurisdictional bars. We have, it's very hard for us to win. But I mean, here is, these are some tools that would allow us, to champion justice, redress our wrongs, help clients, deter bad conduct, and we can actually make money while we're at it. So, we think these are very useful things to learn for immigration lawyers. I'd like to introduce my amazing panel here with me today. First, we have Jennifer Coberly, who's a senior litigation attorney for the Americans for Immigrant Justice. She was a partner in a big law firm before joining Immigrant Justice. She handled, she was the first one to do a family separation FTCA case in the 11th Circuit. And she was chosen by the Florida Bar to argue an appeal in the 11th Circuit. She was on the Florida Bar Board of Governors for 6 years. She's past president of the Florida Association of Women's Lawyers. She went to this law school, some of us have heard of, Yale. Okay, and then next we have Trina Realmuto, the executive director of the National Immigration Litigation Alliance. She's been a legend in fighting for immigration's rights for like 20 years in federal courts. She's litigated and argued precedent decisions, and she won the Jack Wasserman Memorial Award for Excellence in Litigation from AILA. Next, we have Michael Passano, who's a shareholder in Carlton Fields. He also went to this unknown law school, Yale. And he was the chief of the Broward and West Palm Beach satellite office of the U.S. Attorney's Office for many years, and he was a former chair of the ABA Criminal Justice Section. And the last panelist is Philip Kaplan. Philip Kaplan has just done some amazing lawsuits, civil rights lawsuits on false arrest, excessive force. I mean, he's taken on the San Francisco Police Department, the Los Angeles Police Department for cover-ups of homicides. I mean, he's been down fighting these cases for a long time. It says he obtained a reversal by the Fifth Circuit Court of Appeals in a Bivens case, which sounds impossible in the Fifth Circuit, but anyway. Okay, well, thank you. I'm gonna start out. I just wanna ask everybody, all the panelists, if they could just briefly talk about, why you became interested in suing the government. What interested you in doing this? And if you could just talk about a case you have, like let's say an important case that you've been working on. I mean, for Jennifer, for example, I hope it's the child separation cases, which are very interesting. But if we could just start, whoever, I don't know, I guess Trina, we'll go in order. So if Trina could go first.
Sure, thanks. Hi, everyone. It is nice to be here. My first taste of this was a wrongful deportation case when I was an associate attorney in San Francisco at a firm called Vanderhout. And people weren't really doing it back in the late 90s. We got some relief for our client, and then I moved to the National Immigration Project. And it just seemed that immigration attorneys were not getting any kind of training on damages actions, but that there was something called the Morton Memo that came out that sort of said if you have a bona fide civil rights claim, you can maybe get some immigration relief for your clients. And so we started putting on trainings and doing more of these cases and noticing that the intersection between damages actions and immigration cases, could be beneficial and would be another tool in your toolbox. And so I've been involved in a number of wrongful deportation cases, false arrests, false imprisonment, detention of US citizens. Those are another big area. And then, sort of most actively and passionately, I'm part of the litigation team that has the family separation case in Arizona that is sort of the farthest ahead. And we're in the midst of full-on discovery and about to start deposing CBP and ICE officers, which for those of you who have to contend with these officers in your daily practice, one of the best parts of this type of litigation is being able to depose those officers under oath. There is just sort of nothing like it. So I'll leave it at that.
Okay, wonderful. You're amazing, Trina. So Jennifer next.
Okay, I'll be talking about FTCA litigation today. Yet I was first introduced to this area of law many years ago when I worked with my co-panelist, Mike Pisano, on Bivens litigation. He was the expert then, as he is the expert now, so I was able to learn a lot. Prior to joining AAI Justice, I learned that it wanted to file several FTCA claims that had been brought to its attention by its detention program, its children's legal program, and its family defense program. And that was actually what first got me really, really interested in joining AIJ when I learned of that. I started on July 7th, 2020, and filed AIJ's first FTCA case since about 2014 on August 28th, 2020, so a little over a month after I joined. And yes, it was one of the first few family separation cases. I guess Trina and I, we really don't know who's going to trial first because I only have one client and she's got a lot. And so her litigation is much more complicated than mine, but it was one of the first few filed that we did. So I am also AIJ's lead counsel on an FTCA claim involving a Colombian man who sought asylum after being tortured with a blowtorch at home in Colombia, only to flee to the U.S., where he was held at the border in Hieleras and other squalid holding cells by CBP for over 57 days, during which time he was not only repeatedly threatened with tasers, but denied toothbrush, shower, food, and a place really to sleep. So with the help of AIJ's pro bono director, Angela Andronis, we recently signed a co-counsel agreement with Shook, Hardy, and Bacon and have just amended his FTCA administrative claim for total damages up to $1 million from $500,000. So I am engaged in FTCA research and analysis nearly every day, and I'm very honored to present. Thank you.
Great, thank you, Jennifer. And Michael?
Yeah, and it's great for me to follow Jennifer, who has just blossomed and is an amazing lawyer. I'm maybe the black heart on this panel because I'm the guy from that video you watched who would be asked potentially to represent the rogue cop because much of my experience derived from when I left the U.S. Attorney's Office. And then friends in the U.S. Attorney's Office started coming to me with regard to Bivens and FTCA actions in which individuals, maybe it's an agent, maybe it's a prosecutor, maybe it's a jailer, were sued. And I got in on the defense side of it. It opened my eyes because there's a lot of bad conduct. And fortunately, as someone in private practice, I could say yes or no to whether I wanted to get in. I was told by my friends when I first got in that I would be doing God's work because as a private lawyer defending, you don't get paid much money. The government has a contract with you and you're fairly capped. So you're not doing it on the defense side for the money, but if it's a righteous case, And my righteous case that got me interested and started was an airport detention case. It's a long time ago. It's a rookie agent dealing with drug importations. And back then, and this came in Fort Lauderdale as it happened, the drug traffickers were using pregnant women to traffic drugs. And this is a young man who did his best to resolve a situation where the dogs alerted. It was a pregnant woman who seemed very sympathetic and who he detained despite a lot of screaming. And it was an awkward situation. And it was so awkward that when ultimately the case proceeded to a civil Bivens action, the government wanted to settle. But this young guy didn't. It was his career. And that's how I get involved, is when the government perceives a conflict for one reason or another. Sometimes it's a good conflict. People disagree. Sometimes it's bad behavior and the government wants to distance itself. But I became involved in that instance, trying to help someone who I thought deserved to be helped. And we actually won that case on summary judgment. But the issue educated me that there are terrible situations, and then there are situations where someone may have been pulled into a terrible situation and needed a defense. So I'm on that side.
Okay, great. Thank you, Michael. And Philip?
Well, just like Jennifer and Trina, I represent the good guy, like Mike.
Yeah, thanks, Phil.
But the way I went to Tulane Law School in New Orleans and practiced law there for a bit. I was actually doing admiralty. Came out to LA, and I've done a lot of different things, including entertainment, litigation, represented Ike Turner, and I did all kinds of stuff. And then I got a call from a buddy up in San Francisco who was a gang cop. And he had been assigned to administration. It just sounded like right out of a Dirty Harry film. And he had he believed that there was a lieutenant of homicide who had covered up some bad stuff. And he sent a memo to his chain of command. And so the case was a free speech retaliation case, First Amendment case. It was a very fun, interesting case, wild. We had two police captains who were defendants. They were looking at punitive damages. The judge actually let them know that they were in a serious situation, that their houses could be taken. So I saw the power of punitive damages. I'll talk about that later on. So that case really opened my eyes to the issues with constitutional law and First Amendment litigation. As some of us know, the issue of free speech retaliation is very complex, and usually the area where you get caught up and lose is on the area of were you speaking out as a private citizen. So we have a lot of law where if you complain within your organization, the courts are going to say that this is part and parcel of your job duties and you weren't speaking out as a private citizen. So in any event, after that, I started getting involved with some excessive force cases, and I've done many different types of cases, including shooting death cases, and so all kinds of cases. Currently, I'm involved with a case in Louisiana. This is a Iraqi war vet with PTSD, was threatening some behavior that people thought might be suicidal. He ended up being tased and beaten. And we were successful in a motion for summary judgment. It was denied and all ready to go to trial. And then an interlocutory appeal was taken. We've been waiting for almost 2 years. So I'll talk a little bit about interlocutory appeals. So that's some of what I do. And I really appreciate, Robert, you're including me on this panel.
Thank you very much, Phil. You're a hero. Okay, I'm just just briefly my how I got involved. I'm just I'm an immigration lawyer, and I wasn't looking for this at all, to tell the truth. And I had a client, and she was a transsexual, fairly like a gentle soul, and we kind of knew her. We thought it was a pretty good asylum case because it's a PSG. Those who do immigration law know what I'm talking about. I mean, it's a transsexual. So So then she was picked up because she had some prostitution charges, convictions, I guess, and she was picked up and taken to Chrome. And while she was there, she called us and said she'd been raped by a guard. And we just had no reason to doubt it. I mean, we knew she was telling the truth just because she had no reason to lie. And she, you know, I mean, she just, well, you know, there's no reason in the world you're going to make that up when you're detained. And we already knew her. So, and on top of that, they wanted to deport her. So it was kind of an emergency situation. So I organized a press conference, and, you know, you can imagine that's a pretty good story for the press. I mean, it has everything. I mean, Chrome, immigration, transsexuals, rape. So it kind of became a big story in Miami. We were on the news. And then the government actually looked into it. And first thing they did is put my client in a mental institution, which they claimed they were doing it for her sake. But then they stopped, you know, all the deportation, everything. And then they actually found DNA. They found she was telling the truth, and the guard was arrested. Eventually, he was only convicted of battery, which doesn't really make sense, but that was out of my hands. And then at that point, I just, you know, I actually looked around for another lawyer I thought might take the case because that wasn't my field. And then literally, you know, I talked to an ACLU lawyer, and no one really wanted to take it. They're all like, well, she has prostitution, you know, and I was like, how much is this case worth? They're like, well, you know, somewhere between $0 and $1 million. I mean, you know, because rape is worth a lot, you know, for in terms of that, but it's surprised, you know, they don't know if anyone's going to believe her. And I was like, but we got DNA. Anyways, no one really wanted to get involved. So I said, okay. So I looked, you know, I started reading about the FTCA, and I filed a claim. 6 months passed, no response. So then I filed a lawsuit in federal court in South Florida. And finally, I mean, you know, not much happened with the lawsuit other than I did get a call from the government. I guess they figured there's DNA, the guard was arrested. And you know, I talked to the US attorney, and they agreed to pay $60,000. And my client just said, take it. And I said, no, let's wait. And we waited a few weeks. And I think it was basically the last minute when my client wasn't going to wait anymore. And they called back and said they'd offer $95,000. Because they said, you know, the U.S. attorney said his client will never pay more than $100,000, but you know, so we took it, and that was it. It was a happy ending, and I got $24,000 out of it, and the client got paid, and so that's my story, which is pretty much a good story, because you know, when I started out, people were saying, you know, the government will fight you, you know, they'll never settle, and well, they did. Okay, so. I guess it's time to go to the PowerPoint. So our first PowerPoint will be Trina. And Trina's going to give an overview of the Federal Tort Claims Act, you know, tell us basically what it, you know, what it is to sue for torts committed by federal employees and filing administrative claims. So thank you, Trina.
Thanks very much. And I guess in terms of, okay, we're moving right on to the slides. So for those of you who are immigration attorneys who are out there, you are the folks that hear firsthand the stories of abuse and misconduct by federal officers from your clients. So that puts you on the front lines of folks who have access to these types of cases. And so if you've had a client that's been arrested or assaulted, detained when they had status and shouldn't have been detained, wrongfully deported in violation of a stay, for example, or deported to a country without having an opportunity to make a fear-based claim, denied medical care in a facility where there was federal court, where federal agencies were providing that medical care, or other sort of, you know, it runs the gamut, wrongful acts or admissions by federal officers. What should happen is bells should go off in your head, and you should say to yourself, there might be a federal tort claim here. And even if you're an immigration attorney and you have never, ever done one of these cases, I am here to tell you, next slide, please, that doing one of these claims is, yep, no, that's it, rocket science. It is not rocket science, okay? It is a lot easier than you think it is. And at the administrative stage, there is not a lot of legal mumbo jumbo. I'm going to go over all the legal mumbo jumbo that you need to know about for the administrative stage. I am also going to tell you that if you are not comfortable going to federal court, we hope you will be, but you could file one of these administrative claims and then you could deal with the federal court piece of it afterwards. In other words, you could have a limited retainer. in order to do the part before the agency that you might feel more comfortable with. Or you might team up, like, for example, we have a co-counseling program. We team up with immigration attorneys, and we have about 10 to 15 FTCA claims on our docket where we're doing those claims with the immigration attorney so that they know how to do it for the first time, and then they can do it in other cases for other clients, and it's a trickle-down effect. So it is not rocket science. Let's move to the next slide, please. And when we're talking about administrative claims, I'm going to get into the details about what's involved, et cetera. You kind of ask yourself, well, why should I do this? I'm an immigration attorney. I've got cases before USCIS. I've got immigration court. I've got BIA appeals. I'm super inundated. Well, there's a couple of reasons why you should do it. I mean, the main reason being that, one, this is like unfair what happened to your client, but it also is an angle to provide additional access to immigration options. So it is part of and should be part of a holistic, comprehensive immigration court strategy. Now, the administrative claim, which I'm going to talk about in detail afterwards, is a prerequisite. It's an exhaustion issue to filing any claim in federal court. So you can't sort of bypass the admin claim when we're talking about the Tort Claims Act and go straight to federal court. You've got to file a claim first with the agency, and we'll talk about that. We'll go through what's required. And it's not a lot. This is the part that is not rocket science. So what can you get? You can get money for your client. As I said, you can improve immigration options, because sometimes, and increasingly under this administration, I think it's not true for the last administration, but you can settle FTCA claims either at the admin stage or after you survive a motion to dismiss in federal court for some type of immigration relief. And that is invaluable, because as your clients know, many of your clients will tell you it's not about the money, it's about the immigration relief. They need that sort of security, and this is one way to get it. In addition, you are shedding light on what happened. You're holding government officers accountable. And we'll talk about this momentarily. But as Robert was alluding to earlier, there is a capacity for a recovery of a portion of the award for attorney's fees. So it's a contingency fee type case. You go out of pocket at the get-go, but if you're successful, you can recoup a percentage of the award. So those are reasons to do it. And as I said, don't shy away from it because you think it's difficult. But let's talk about it and why it's not so difficult. Next slide, please. I want to start very briefly with just an overview. When we throw out FTCA and the Federal Tort Claims Act, on your slide there, you have the statute and the relevant regulations that sort of make up what we call the FTCA. And what is, the Federal Tort Claims Act? You are basically suing for a tort, which, if you remember from your first year law school classes, is a wrongful act or admission that arises to civil liability, giving rise to civil liability. And we'll talk a little bit about what those torts are, just to refresh your recollection. But this statute allows for the tort claims to be brought against the United States, right? And so when you're dealing with the FTCA and you get to federal court, and I'm sure Jennifer will talk about this, your defendant is the United States. And who is the United States? It is the executive agencies of the United States as well. And when you're establishing liability for torts, you're dealing with standards of proof that are set by sort of state tort law. And for many instances, that standard of proof is going to be substantially less than what is required to show a constitutional violation. And so you don't have to be freaked out about torts. You just have to know that at the federal court stage, you're going to be looking to state tort laws and what's required. We have a practice advisory. My organization, National Immigration and Litigation Alliance, has both a practice advisory that has frequently asked questions by immigration attorneys that walks you through some of these questions that pop up as an immigration attorney. And in addition, we have sample packets of how to walk through these things I'm going to be talking about. So let's move to the next slide, please. So the very basic information that you want to know about this statute is that there is no right to a jury trial, that it is a judge who, if you went to federal court, would be deciding the amount of damages. And I can assure you, I've been doing this for 20 years, very few cases ever in the immigration context go to an actual trial. With the exception of the track of the family separation cases, there's only been a handful that ever make it to trial. Monetary damages are available, and so you're looking at how much is the tort worth, and we'll talk about how you can calculate that, not punitive damages. But as I said, when you are negotiating, we'll talk about negotiations, you can ask for immigration relief in lieu of lowering the amount of monetary damages. However, you can't go into an FTCA claim and say, I just want immigration relief. That's not going to fly. You always have to provide some cert, and you're going to have to calculate what you think the amount of damages is. And we can talk about that. And it's one of the things that we do. We help people think through and strategize about what is an appropriate amount to put down on that request for damages. We were talking about attorney's fees and how attorneys can get a cut of any settlement or award by the federal court in an FTCA case. If you settle the case at the administrative stage, meaning before any federal court complaint is filed, you can settle the case for 20% of the overall award. If you are forced to go to federal court and you file that complaint, and then the case settles, even if it settles the day after the complaint is filed or after you survive a motion to dismiss, your percentage of recovery is going to be 25%. Next slide, please. So we're talking about torts, right? And I just want to get the cobwebs out for those of you who are, focused on asylum and cancellation and TPS and all those forms of immigration relief. This is bringing you back to, like I said, that first year of law school. And there are two sort of types of torts that are compensable under the FTCA. There are the negligent torts, and that is negligence, negligent infliction. Can you go back, please? Infliction of emotional distress. And there are things like wrongful deportation in violation of a stay, or while a person has an appeal pending at the BIA, I've had that case also, and negligent attention for medical care. And then there are intentional torts that are under the FTCA required to be committed by an investigative or law enforcement officer. And some of those torts include things like battery, false imprisonment, false arrest, abusive process, malicious prosecution. Those are sort of the types of torts, and you have to look at your state law to see what the elements of these torts are, and you're going to want to just refresh your recollection of those elements. But importantly for immigration attorneys, when we're talking about who constitutes an investigative or law enforcement officer, the statute requires that the person be sort of empowered to execute searches and seizures and make arrests, etc. So most immigration officers, CBP, ICE, and some USCIS officers, FBI, Marshal Service, these are the federal officers that our clients are interacting with, will meet the definition of a law enforcement officer. And so therefore, they can be implicated in battery, false imprisonment, false arrest, all those types of torts that we see. Now, there are a couple torts that are not actionable under the FTCA. There's something called the law enforcement proviso, which is just a fancy word for saying you can't sue for certain types of torts. Those are here on your screen, and they include things like slander, misrepresentations, deceit, libel, interference with contract rights. So just, bear that in mind. But at the admin stage, you're just looking to see if there's some tort that might match up with what happened. At the admin stage, what I'm talking about, you are not going to be saying, and you do not have to say, well, this was negligence, this was abusive process. You don't need to say that. There are just certain requirements that you have to make at the admin stage. And that's why I think it's a lot easier than you might be thinking. But let's talk about, let's go to the next slide and move to the different types of actions, or the two steps that we have in the FTCA process, and then what's involved in that admin stage, right? So there in this type of practice, you have to file the admin claim before the agency. And that's what I'm talking about. If that is not successful and you would like to go to federal court, and Jennifer will talk about this, then you can go to step 2, but you can't go to step 2 right away. You've got to go through step 1. So let's move to the next slide and start talking about that exhaustion requirement, the step 1 thing that I'm kind of going on about. Can we move to the next slide? Thank you. So this is what I've been saying. The statute says you can't go to federal court unless and until you've submitted this claim to the agency. And this claim has a timeline. It has a statute of limitations, and it has to be filed within 2 years of the claim accruing. That should be your benchmark for when you need to file. If the action happened that was the abuse or misconduct, you want to calculate 2 years, and you don't want to cut it close. You want to try to file your admin FTCA claim a little bit before that statute of limitations runs. But I will say that in a 2015 case, the Supreme Court held that tolling is available for the administrative stage. It also held that tolling is available for the district court stage. But if there's a question and you're running up against statute of limitations, this is the kind of thing that we brainstorm with people, and we look to see if there's any kind of creative arguments that could be made around the fact, for example, the person might not have known the tort accrued. And so then you can make an argument that the accrual sort of starts upon the discovery of the tort. Okay, so that's exhaustion. Let's talk now about what it is we're actually filing, right? So at the admin stage, so NYLA, my organization, has prepared a packet, right? We have prepared a sample cover letter. Don't have to file a cover letter, but just like with anything else, you're gonna want to file a cover letter, right? It's got your letterhead on it. You're saying, hey, I'm presenting this claim. This is who I'm presenting it to. It's a short cover letter, but you're just saying, here's what's included in this packet. What is included in the packet? You have a claim authorization form notice, which I'm going to get into in detail, but that just simply says, hey, I'm authorized to be filing this claim on behalf of my client. The statute requires that you provide written notification of the incident, and you can do that in one of 2 ways. You can do the form SF-95, right? Or, and complete that, because that is the government form for filing these types of claims. And it has all the questions that they're gonna wanna know answers to. But you can also provide a letter that talks about what happens and provides all that key information. So some attorneys prefer to use the form and attach supplement to it. Other attorneys just do it by letter. It doesn't matter. We sort of recommend the SF-95 because then we can be sure that you've filled out and completed all that information that's required. If you do it by a letter, you have to include a sum certain. That's the amount of damages you're requesting. And bear in mind that if you are doing it for example, a parent and a child, each person, each claimant requires their own SF-95, right? Their own sort of separate claim. You can't clump them together. They have to be sort of separate. We like to provide an index of exhibits and supporting exhibits. If it's a technical claim, for example, wrongful deportation, we're trying to say, what happened, why the person had a stay and they were unlawfully deported. So we'll put a copy of that stay in there, just to help the attorney who's going to be reviewing the claim out understand what was happening. But exhibits and exhibit lists are totally 100% optional. You don't have to do them. And of course, if you're running up against the statute of limitations and you don't have time, you're not going to have time to do that. So let's talk a little bit more detail about what is required. And so we're going to go into a little more detail about the claim authorization form. So this is something that is required. You have to have authority. That's required by the regulations. And they say that the claim is deemed presented, right, when the agency receives either the SF-95 or that written notification with a sum certain. And it has to be from the person, his, her, their self, who are presenting the claim. Like, people can do this pro se. They don't have to have an attorney, do it on their own. But, for this group, or it has to be, you have to have authority that you are the attorney or the agent representing the client. And so you have to have provided your title and your capacity that you're representing the claimant in. So for most of us, it's just going to be, as their attorney. And we have a sample claim authorization form in both English and Spanish that is in the packet of materials that you'll get after this webinar. And so it's all right there for you, and it has the information that you need. If you are representing a child, then you have to have somebody with capacity to sign that claim authorization on behalf of the child as well. The claimant need not be in the United States. We've seen this particularly with the family separation cases. So it is not a mandatory that they're in the United States. Okay, moving along to the next slide. Nope, notification of incident. Thank you. So on this one, this is what we're talking about. We're saying, it's good to use the SF-95 because it's got everything. But there's also questions on that SF-95 that basically says what happened. And our position is we usually write C attachment, and then we explain in detail what happened, right? What was the wrongdoing? Because that form is tiny. There's not a lot of space. So it's okay to write C attachment and attach, a fuller explanation. But there are two, on your slide here, you'll see that there are two different circuits, the 5th and the 9th, who have sort of talked about what is sort of notification of the incident. And both of them stand for the proposition that it just has to be sufficient information that allows the agency to be able to investigate potential liability, right? You have to be able to give a general description of the time, the place, and what happened. It is the what happened aspect of it. But notice that these cases do not say, and you have to identify the tort. You don't have to identify the tort. You have to put the agency on notice of what happened. Some lawyers like to lawyer it up and put, and this is negligence, this is abuse of process, this is whatever. That's totally fine. You can do that, but you don't have to. And for those of you who are in high volume practices and trying to give your clients an additional option, you might not have time to do that, more detailed digging, at the administrative stage. Okay, so let's move on to the some certain aspect of it. This is also required by the statute that you have to give the amount of damages that you're seeking. And critical here is that the number that you put, the dollar amount that you put on your form is generally going to serve as the cap on damages that are available to you on the amount that you're going to be able to recover either at the admin stage or the district court stage. There's exceptions based on if there's new evidence that comes out that there's no way you could have discovered, or if there's some intervening facts, related to the amount of damages. But because of this statutory cap, right, the practice pointer here is to aim high so that you don't, unnecessarily cap your client's recovery, right? And so that is just a practice pointer for folks. And the way you ascertain amounts is you look at what previous, torts of the nature that you're alleging have, what state courts have awarded for that amount. You can also connect with us, and we try to track what immigration damages torts have been recovered, what similar amounts. Sometimes for the wrongful deportation, the wrongful detention, you're going to want to negotiate on a per day amount. You can use a calculation there. False arrest, false imprisonment, those are numbers that are out there in state court. You can also consult with a personal injury attorney in your state and just to get a sense of what those numbers are. There's lots of different ways to think about, what is the amount that your client is seeking to recover. Okay, let's move to the next slide. So that's everything about what to file, right? Which is not that much when you think about it. But where do you file? So you want to file it with the agency or the agencies employing the officers that gave rise to the claim, right? So that might be CBP and DHS, it might be ICE and DHS, it might be just CBP, it might be just ICE, whatever the case may be. But if there's more than one agency involved, if ICE and CBP were involved, for example, you can send it to both, right? But one of the agencies is going to be designated as the lead agency, and one of the agencies is going to be responsible for handling the claim at the administrative stage. So as what we recommend is that you kind of send the claim to the Office of General Counsel. There's a regulation there that sort of says that they are the ones that accept service of grievances, and as well to the General Counsel of the agency that employs the office. These agencies now recently have come up with email addresses that do not actually, that are just a courtesy. They ask you to send complaints to the email addresses as a courtesy copy. We recommend that you also email the complaint, because then you'll get an immediate sort of proof of receipt. And so whatever you do, though, you don't want to substitute emailing your claim for also sending it by a way that you can track so that you have proof of compliance with that statute of limitations. In the packet of materials that I've been kind of going on about, we have a list of service addresses for all sort of the common immigration agencies to make it easier for you. So you can just take a look at that. Okay, after filing, you should receive an acknowledgement, but truth be told, we have heard anecdotally, and we have experienced this ourselves, the agencies are really behind and you don't necessarily get proof of an acknowledgement from the agency on a timely basis. That is why it's so important to keep proof of compliance with the statute of limitations, proof of delivery. The agency has 6 months to review the claim. I'm going to talk a little bit more about that in a sec, but importantly, you can amend that claim within the 6-month period, and that's going to start a new clock of 6 months to review the claim. Under the statute, if the claim's not settled during the review process, and that process can go on for a little while, it's sort of deemed denied when the agency issues a formal written decision. But it can be also treated as constructively denied if the agency hasn't done anything, but that is up to the claimant to decide. The agency could just sit on it and do nothing, and that theoretically could be considered a constructive denial, but you don't have to take that to federal court if the agency just hasn't done anything. Let's go to the next slide, because I'm trying to fit this all in in my allotted time. So after filing, what could happen, right, is the agency can ask you for more evidence. They can say, show us the emotional distress that you say your client suffered. Show us the medical harm that you say your client suffered. And you can provide that. It's not absolutely mandatory, but you might want to, because you might want to establish the damages and the liability. It's generally taken as a good sign that they are going to engage with you at the admin stage. So I would take that as a positive sign. They can make a settlement offer. You are entitled to make a counter offer. They could deny the claim. And if they do issue a formal denial, that means that you have 6 months to go to federal court. They can also do nothing. And if nothing happens, you have 2 options. You can treat it as a constructive denial after 6 months and go to federal court, or you can sit and you can wait for the agency to act. Personally, for the cases that we do, we reach out, we try to find the point of contact, and we start engaging in settlement negotiations. That's particularly helpful if what you're going to be trying to do is to negotiate for immigration relief, because that's a little bit, out of the ordinary, and it's in your client's best interest usually to have that, process start happening. So if you're interested in settling the case at the admin stage and then not going to district court, you should engage with the agency, and we can talk through about how to do that. Last but not least, remember, really important, your ethical obligation here when it comes to settlement. It has to be in the client's best interest. And as I said, in immigration cases, Money is not always what the client is seeking, in their best interest. They may be interested in some other type of immigration relief. So you have to keep that in mind. And if you get that, you have to agree to that, because settlement decisions belong to the client. And that is really, really important. Any settlement offer, if you are having a conversation with a government attorney, you cannot accept or deny on the spot unless you have express consent by your client. You have to bring that to your client. You have to keep your client informed of those negotiations, and you have to remember you have no authority to settle the case without having a conversation with your client. And when you do have that conversation and you do get a form at the settlement stage, explain that to the client in plain English. Oftentimes, and this will get discussed later, for the FTCA case, if you settle the FTCA claim, it means you've settled all the claims that rise out of that issue. And so you can't then bring another lawsuit on the same set of facts. And the judgment bar, I think, probably will come up afterwards. And so, yeah. So finally, if you get an approval settlement, if you are settling a case on behalf of a minor, you have to look at what your state requires in terms of approval of settlements for minors. Last slide, and then I will turn it over to Jennifer. I'm sorry, I'm just 1 minute over. Here on your PowerPoint, which I believe you're going to get after this conference, you have a list of materials that are hopefully helpful to you in preparing your FTCA claims and litigating them in federal court. Thank you.
Thank you, Trina. I guess everybody can see why, but when we talked about the panel, everybody wanted Trina. So now next is Jennifer, who's going to talk about going to court in cases basically like my case, where the government doesn't even answer, or we don't get any type of settlement negotiations or discussion at the administrative stage. Then you head to federal court. Thank you, Jennifer.
Hi. For this portion, I'm hoping that everybody has had their second cup of coffee, because the litigation is much more complicated than the administrative process. And this CLE was billed as intermediate level, and I'm really not covering all of the basics. For instance, I'll throw a couple of out that are good to know, which is the only defendant is always just the United States. And these are always tried to the judge only, but those are basically the only two basics that I'm covering, because I'm covering intermediate material here. And what I've called my PowerPoint is the user's guide to how to avoid dismissal of your FTCA claims. And the reason for that is that there are 3 robust statutory hurdles to overcome: the discretionary function exception, the due care exception, and the private analog requirement. I will be most likely covering 2 of these today during the actual presentation, but all of them are covered in the PowerPoint. And my understanding, I think someone had asked in chat that there will be distribution of the PowerPoints to all of the people who have actually attended today. And I am going to cover one thing that is surprisingly tricky and is not one of the major defenses or requirements, and that is that there's a lot of variance between when state law and when federal law applies. So you kind of have to double check in every instance. I'll be covering some of that. But equitable estoppel, the federal law of equitable estoppel, applies instead of any state statute of limitations, and it's generally not as friendly. Here in the 11th Circuit, it's distinctly unfriendly. Equitable tolling is by definition extraordinary circumstances, but the extraordinary circumstances are considered quite differently from circuit to circuit. So in Harris versus the United States, Harris showed or alleged a number of extraordinary circumstances with respect to her mental health and capacity, but the court noted that every month in the 2-year tolling period was not adequately covered with her mental health capacity, and therefore her case was dismissed. All circuits do not agree on this. The 10th Circuit, for instance, takes a more holistic balance of equities approach, and Reed versus the United States is a good case on that at 626 Federal Appendix 766. So whatever your circuit in, circuit you're in, your lead for research should be United States versus Kwai-Fun Wong, because it was only in 2015 that the Supreme Court came out and said what's going to govern each and every FTCA case is going to be the federal law of equitable estoppel. So that's the place to start. Anything before that is essentially irrelevant. So the first big exception is the discretionary function exception. This particular statute covers both the discretionary function and due care, but I'm not going to be covering due care today if the time goes the way I think it's going to go. So the discretionary function, this is an exception. So that basically Chapter 171 of Tort Claims Procedure lists all the ways in which you can bring a tort, and this tells you the times that you cannot. And one of the times that you cannot is if a discretionary function is involved. And the only way to really understand that is to look at the case law. And the lead case is United States versus Gobert. And it's a two-part process. Number one, did the actions involved an element of judgment or choice? So if there's a very on-point statute, regulation, or directive and a policy, then the discretionary does not apply. However, the second element is there a judgment of choice? Is it of the kind involving legislative and administrative decisions grounded in social, economic, and political policy? And unfortunately, like I said, you're going to be very dependent on the judge that you're assigned. It will definitely go to a judge. So the almost any judgment or legislative, administrative decisions, almost all things that are pursuant to law relate in some way to social, economic, and political policy. And I'm just going to give you a few examples to lay out the terrain of places where the discretionary function was held to apply and thus be the basis for the dismissal of lawsuits. In Medina versus the United States, Fourth Circuit 2001, a decision to arrest was held to be a discretionary function. In Hensley versus Standing Rock Child Protective Services, the Eighth Circuit in 2008, the decision to place a former child molester in a foster home without warning the host family of past abuse was held to be discretionary. Case dismissed, or it could have been summary judgment. Decision to not supervise ROTC organization was discretionary function. No liability for death in a hazing incident was the Mercado del Valle versus United States, First Circuit 1988. Also, a decision to not place a guardrail along a roadway was an exercise of agency discretion. Bowman versus the United States, 820 F. 2nd, 1393, Fourth Circuit 1987. And finally, in Schuler versus the United States, a decision regarding the scope of protection afforded to a confidential informant was discretionary. In this case, there was not much protection. Identity became known. The informant was shot, resulting in permanent paralysis. So what you get is that there's a I'm going to be skipping the due care exception. What you get is that there's a very strong discretionary function exception. And so I have three favorite ways to defeat the discretionary function exception. You'll understand in a minute why this is one of my favorites. So the law enforcement exception. So this is an exception to an exception, meaning that these claims can only be brought under the FTCA against law enforcement officers. So assault, battery, false imprisonment, false arrest, abusive process, malicious prosecution, only against law enforcement officers. The reason that I like it is because I'm in the 11th Circuit, and as you will learn in a couple more minutes, we deserve a break now and then. And I believe that we're the only circuit in which the law enforcement exception has been held to trump the discretionary function in the 11th Circuit. So if you do, in fact, bring a claim, and this is the case in Nguyen, if you do, in fact, bring one of these cases in the 11th Circuit, and against, you can only bring it against a law enforcement officer, that is not going to be subject to the discretionary function exception, which is a wonderful thing. this one is a little more depressing for me, which is why you see that's basically my sad face. But generally, unconstitutional conduct, if the conduct that is involved in the tort is in some way unconstitutional, most circuits will say that the discretionary function exception does not apply. The lead case is Lumiere versus United States. It collects cases. And I've checked this pretty recently. I'm pretty sure that all of the ones that are listed are still as listed. I recently found that this would be a very helpful argument in the family separation Federal Tort Claims Act case that I'm litigating. And I relied on a 2009 case, Denson versus the United States, from the 11th Circuit, that basically had dicta. So it mentioned a couple of times the government officials lack discretion to violate constitutional rights. That actually went pretty well for me. I made that argument in February 2021, and the judge agreed with that argument, which was very good. The judge did mention that she had otherwise had some concerns about discretionary function, and I think that that's not an uncommon thing that comes up in these types of litigation. Then I think it's 4 or 5 months later, in June 2021, the Shivers versus United States case came down, holding that, in fact, there is no constitutional claims exclusion in the 11th Circuit, meaning that although the conduct associated with the tort was, in fact, unconstitutional, there can still be discretion. This Monday, I believe it was, the Supreme Court denied cert, which is really, really good for all those circuits that will still be able to argue that unconstitutional conduct trumps the exception, but it's not very good for the 11th Circuit. So finally, this is something that everyone can use pretty much equally from what I've seen, which is pleading all statutes, regulations, and policy or manual directives or requirements that, if complied with, would have prevented the tort. This is, again, essentially under the Gobert case, because it's a discretionary exception. It's a discretionary function. If there's no discretion, if there's something close enough to point, then it will not apply. And one good example is the Douglas versus United States case out of the 11th Circuit, in which Bureau of Prison Regulations were held to allow no discretion to refuse to pay wages, and the refusal was not grounded in policy. So if your client suffered injury while held at the border in unsafe conditions, you might consider alleging every statute, CFR, and requirement, every internal policy manual. So for instance, there's hold rooms and short-term custody directive, national standards on transport, and all other items that you can find like that. If your client was injured due to excessive force, again, you would probably want to plead and include allegations relating to the 2018 DHS policy statement, the ICE 2019 national detention standards, and other things along that line. So I have a few minutes left, and I have a really big issue to cover, and that is, again, if you can get the slides, and there will be more detail, but the private analog requirement the basis of it is 28 U.S.C. 1346b1. That's the statute that specifies original jurisdiction for federal torts, and provides that they will be allowed only where a private person would be liable to the claimant in accordance with the law of the place where the act or omission occurred. The private analog requirement. It is well recognized that the federal government can never be exactly like a private actor, but what is required is that a plaintiff needs to make a showing that state law recognizes a tort on a similar fact pattern or a very similar fact pattern, depending on your judge. So for instance, in the family separation case, you're going to need one of these for every single tort that you allege. So for intentional infliction of emotional distress, my clients crossed the border in California, therefore California law applies. And they have, sometimes the states that have a lot of case log versus say California versus Wyoming, California it's going to be a lot easier to establish an analog. They had a case that said that the unlawful taking or withholding of a minor child from the custody of the parent or guardian constitutes an actionable tort, and specifically said intentional infliction of emotional distress. That was very helpful. Similarly, we had a claim for negligence, and California had some very good cases recognizing that one with the actual custody and control over a child that willfully causes or permits the child to suffer or inflicts unjustifiable physical or mental suffering. And in this case, the child involved in our cases, in most every case of family separation, was really mistreated in ways that will probably have lasting effects, various shaming incidents, not to mention the actual being physically pulled from your family, from your parents' arms. Those are things that are clearly upsetting. So then I do have a few odds and ends. Venue, I think, is important, but mainly for what can go wrong. There too, you can either be where the act or omission occurred or where the plaintiff resides. But if those two places are not the same, depending on how useful it is to the government, it is not uncommon to see transfer of venue motions. So you may want to think about in advance, can you handle that if that comes up, mainly looking probably at forum nonconvenience issues. There used to be an argument that was around for a while, you hardly see it anymore, that immigrants really couldn't reside due to their immigration status. But I think that's been largely rejected, but you still will probably face, you could face a transfer venue motion. And if you can't handle transferring the venue, you really need to be careful with that. And choice of law also comes up. It's normally in the state where the tort occurred that the choice of law will apply. But if there were significant acts or omissions in more than one state, it gets a lot more complex. And I just am listing a case there that lists 5 different approaches. And if that comes up for you, you can look at the 5 different approaches. But it's everything from having the type of claim, having a different approach, to various weighing of what happened where. So it can get, if you have this situation, there's an added level of complexity that you should be aware of. And finally, I would be truly remiss if I did not mention at this FTCA Bivens seminar, the judgment bar. And that is that any judgment, whether favorable or adverse in an FTCA action, actually will bar any judgment against an individual federal officer. So anything in your Bivens. And this actually applies retroactively. So even though you may have gotten a Bivens judgment, it will be wiped out if the FTCA claim, favorable or not, there is actually the judgment issued. So that's a lot of material, and I know I'm a bit of a fast talker, but we do, I think, have some reasonable amount of time set forth for questions. I've seen some of them come up in the chat that will probably be easier to just answer in person, but I'll just go ahead because Sabrina has been a good friend to me, that yes, there is an issue. I saw your question in the chat, Sabrina, that there is an issue with GO. I think that the rule, and I don't have the case in front of me, but the rule is that the United States is only subject to liability for negligence of an independent contractor if it can be shown that the government had authority to control the detailed physical performance of the contractor and exercise substantial supervision over its day-to-day activities. So just wanted to get that.
So can I extrapolate on that, especially for those medical providers, right? So if the medical provider is Health and Human Services, there is a Supreme Court case called Huey versus Castaneda that says your remedy is only under the FTCA. But in these situations where you have GO providing the medical care, what you're going to want to look at is the contract between GO and ICE, and NIGC has a great sort of repository of those contracts, or you can FOIA for those contracts, because what you're looking to see is, if you want to sue under the FTCA, is does ICE have supervisory authority over the medical professionals in that facility? And if so, and they weren't exercising their duty to perform the medical checks as required, you may have a negligence claim against ICE. And so I would strongly encourage you to look for that contract before while you're making that assessment.
I agree, absolutely.
Okay, thank you, Jennifer. That was amazing. Now we're going to do some questions and answers. We've got a lot. I wasn't quite expecting that many, so let's try to get through.
Bang out a couple of them pretty quickly, though.
Yeah, probably. Okay, let me just ask first, just my own question here, which is if you guys could just briefly, and I know that's not going to be easy, but talk about the family separation cases you're handling. I think that's super interesting to everybody. This was just such a barbaric thing that our government did. Separating parents from their children, and and to do this intentionally, this kind of horrific act. And you guys are at the forefront of this. If you could just briefly talk about where it's going and how the cases are being handled. I'm curious also how you're getting around all these bars that Jennifer and also Trina were talking about. You've got a discretionary function. Why isn't that discretionary? And then is this negligence? Is this intentional? Obviously it's intentional, it's not negligence, but if you could just get around some of the fights you're having.
Sure.
Trina, you look like you want to go
happy to take that because I also think that we can get through some of these questions, so people can get their questions answered. But so I'm part of a litigation team. We represent 5 families that were separated that are actively in litigation and about 14 admin claims that are pending. And we have been joined with another case. This case is in Arizona that has an additional 5 or 6 plaintiffs. And so it's a big litigation team. We managed to survive a discretionary function motion to dismiss challenge that was, based on private analog arguments, discretionary function arguments, due care arguments. Those documents are available to read. I think it's almost too complicated to get into, in a 10-minute Q&A session. But the gist of it is, right, this is unprecedented. And the district court found, partly based on the Supreme Court or the California court's decision and Ms. L, that the separation violated due process, that it was an unconstitutional act. So that was helpful. And there's a lot of things that the government that has come out in the discovery that has sort of shown that this was a policy that was meant to deter people from entering the country, which was impermissible. But as a result of surviving that motion to dismiss, our team sort of led in consultation with all these other groups that have filed FTCA claims, including Jennifer's group, we led this coalition to try to resolve the matter. And the government walked away from those discussions sort of inexplicably and abruptly. And I won't really, I don't think this is appropriate to get into here. But I will say that the cases now are, there's at least, I think, 20 federal court cases happening. Our case is full on discovery mode. We have a very aggressive discovery schedule. We're starting depositions next month. We've got thousands and thousands of pages of documents about this policy from the different agencies. And, I think we are going to see some district court judges, be awarding a significant amount of damages because these stories are horrifying, ripped from, hands, and really horrible things said, kids treated terribly, abused in these detention facilities. I could go on and on, but I also want to get to people's questions.
Yeah, and just really briefly, without getting into detail, there was a case, it wasn't directly on point, but it did involve family separation in Texas, and the discretionary function was successful there. So this isn't, depending on your circuit, this isn't going to be a cakewalk. The constitutional argument was extremely important in the Arizona cases. I've read at least all the original briefing there, certainly not all of the briefing. And but I might have mentioned something about law enforcement exceptions. So my case will survive summary judgment because I have assault and battery. Whether the other claims will survive, that will be involves I think that they will, but it will involve a very complex analysis. So exciting times ahead for both of
Yeah,
us.
and if I could
So-
just jump in for a sec, just to underscore something that both Karina and Jennifer had said about settlement. My experience as the guy that sometimes gets called in when there's a conflict is that these days, the government wants to settle. It wants to avoid the bad facts. And the government is of late in a very bad light with a lot of this misconduct. So getting through the legal side enough to get you a foot in the door, gets you a chance to head off maybe some of the later problems if you can work through something that fits what your client wants and gets some resolution. So it's not as dark a picture as it may sometimes seem.
Yeah. Thank you, Mike.
Just briefly, I mean, that's super interesting, but why does it, you both agree that it's really important that you pass the constitutional test. Why is that important with the FTCA, which is, to my understanding, really about torts?
Because of the discretionary function.
Right. It's essentially developed under case law that will defeat the, in some circuits, that will basically disable the discretionary function exception, which is the primary thing that's litigated. So it basically disables that, and it's very important.
Thank you.
I mean,
Okay,
there are
let's
other
take-
arguments that go with it too, but just in terms of people who are listening to this webinar, I think that there was a question. There are two questions that sort of ask, can you bring an FTCA claim? One involves, when the officer is a USCIS officer, and the other involves when a stay is denied and then the person is subsequently killed. When you are talking about an immigration case that is being adjudicated, like the stay that is denied and the person leaves the country and then something bad happens, they went through that judicial process, right? And the court declined to grant the stay. And so there is no FTCA claim, and there is no FTCA claim for things that happen outside of the United States. So that's like one part of a response. And the other thing is, I think Maria had a question about a USCIS officer who was basically assaulting the client, very abusive with the client, right? And so when you're doing these kinds of assessments, you're looking, is there a negligent tort, right? Are they negligently inflicting emotional distress? Are they doing something that is a breach of their duty? And then when the officer is a law enforcement officer, and some USCIS officers are, you just have to look at that specific officer's job description. You're saying to yourself, are they doing an intentional infliction of emotional distress? Are they assaulting the client? And remember, some, assault can be with words, right? And harassment and things like that. So I think that for the most part, when you're talking about adjudications, you really have to have officers that are doing some type of misconduct, and that misconduct has to sort of not be tied to necessarily, to make it seem like you're just unhappy with what the court's decision was or the adjudication decision was. And happy to explain and follow with people after this webinar as well.
Okay, so we have a question, is medical malpractice actionable under the FTCA? My understanding, the answer is yes, right?
Yeah, negligence of all kinds is covered. So, however, you have to look at the state that's involved, and there are cases that if the state has caps or other requirements, you have to basically make sure that it would survive whatever you do has to survive all the requirements. Like Florida has a lot of med mal.
You have to look at who was providing the negligent medical care. If it's Health and Human Services, you look at Huey versus Castaneda, FTCA is your only remedy. If it's an outside contractor that's providing that medical care, then if you want to do an FTCA claim, you have to look at what the contract is with that independent medical provider.
Right, but the idea that it's negligence of all kinds is covered. So if I guess, I don't know, but if the United States were ever covering it directly.
Not a federal actor, right? Then
no,
you don't have an FTCA claim. You're looking at things like 1983.
Unless you find yourself somehow in medical care being directly given by the United States, which is probably a scary concept, so.
Okay, next question was, I guess we already answered this. Is there any basis for filing a claim under FTCA for an adverse decision from USCIS? The answer is no, right?
The only exception that I've seen to that is if the person is basically assaulting you and sexually harassing you, and you report them, and then they change their decision about what they were going to do, that's a federal tort claim. So it's not the actual denial of the claim or handling of the claim, but rather the torts that happened at the same time. So no, it has to be a standard tort. It cannot be, I've never, in other words, it has to be a standard tort recognized under state law. It can't be some kind of, you didn't handle my case right. That's
Right. I mean,
not
that's
not
just
a
going
tort.
to be a super uphill battle. I mean, you're dealing with discretionary claim. No, it's no intentional tort other than a law enforcement officer. Okay, next question. Where a USCIS officer is informed of severe domestic violence in which a U visa was granted and then he verbally attacks.
Yeah, I think I talked about that.
Yeah, you talked about that, but I don't know.
Yeah.
Did Jennifer want to get in on that at all?
No, I think I agree with Trina.
I think there are two that are left and we only have like a minute. I don't know if you want to cover them.
What were the other two?
The one is, there's a really good question about jurisdiction stripping statute for expedited removal and FTCA claims. And it's not something that we got into a lot. It comes up a lot in Bivens context, right? But when you file these cases in the district court, the government is going to try to argue that 8 U.S.C. 1252, the judicial review provision, or INA 242, bars jurisdiction over the FTCA claim because you're challenging, the execution of a removal order or the commencement of proceedings. That will come up. And then the expedited, FTCA is not a workaround for judicial review of an expedited removal order, as Jennifer was saying. You can't use the FTCA to sort of change the outcome in the, to challenge the expedited removal order. You can only challenge the improprieties in the manner in which that process was carried out. And I think the FOIA question was response to my comment before about FOIA-ing for the contract. And I was saying that on the National Immigrant Justice Center website, those contracts, they do a lot of FOIA work and a lot of those contracts are there. But otherwise, you need to file an independent FOIA for the contract governing the healthcare of the facility.
Yeah, I had seen this stripping coming up in all kinds of weird situations lately, like access to counsel. And so, yes, I don't know if it's going to become the standard, but yeah, it's a concern. I agree. So.
Okay, so yeah, I guess that's it. So we've reached our the end of the question and answer. Right now, we have more questions and answers at the end. Trina and Jennifer, don't go anywhere. So we're going to take a 10-minute break, and we'll be back for Bivens after that. Okay, thank you. Okay, so let's keep going with Bivens claims, which is the second part of our webinar. And Michael is going to be discussing, basically giving an overview and explaining what Bivens is. Basically, I mean, my understanding of Bivens is it's a court-made remedy for constitutional violations as opposed to the FTCA is tort violations. I know that Justice Brennan basically created Bivens. He wrote the Bivens decision, and then he wrote the only other decisions that have extended Bivens. And basically what he said is, he said, what use is, a constitutional right if you can't enforce it? And there was no enforcement mechanism, which, was also in Marbury versus Madison. And it's also pretty much common sense. So if you could go ahead, Michael.
I will, and thank you again. So we're going to talk Bivens. We have a slide deck. I'm going to move through it quickly. It's important to point out that, as Robert said, this is a court-created doctrine. It does allow you to sue not just the government, but individuals. So we have the Bivens case. It extended this, or it applied this right of action in the context of violations of the Fourth Amendment. Later cases have extended it to the Fifth Amendment and the Eighth Amendment. You can go to the next slide. I'm not going to talk about this because it's been covered. Well, okay, so the prerequisites, I'm not going to talk about, but SCOTUS, Supreme Court. Now, I've talked earlier that I'm a guy who sometimes represents individuals. I will not and cannot defend the Supreme Court, particularly with regard to the majority opinions in these Bivens cases. So know that in the Bivens context, and it's important to read these cases, the court has consistently pushed back against what they call Bivens expansion. That's a popular new word. It's a bad word. If you believe in Bivens and the right to be able to pursue bad actors, you have to hate what's going on at the Supreme Court. And what the Supreme Court's analysis is now doing is essentially looking at new Bivens claims with two concepts in mind. There's two considerations that they apply. First is it a new type of Bivens claim? And then secondly, even if it is a new claim, something that hasn't been considered before, is it something for which factors exist that would counsel against extending the Bivens case to that particular set of facts? They call it special factors that counsel hesitation. And usually, and in the Hernandez versus Mesa case in 2020, it's a good example. That's the border shooting case. They found that it was very much a new claim. They didn't have Bivens actions for cross-border shootings, but how dare they think about expanding the doctrine of Bivens when there were foreign relations concerns or whether there was a risk of undermining border security. So know that the Supreme Court has been hostile to the Bivens cases that have been arriving at its desk. Next slide. So the concepts that we mostly see, either in prosecuting or defending Bivens actions, circle around immunities. There's absolute immunities. I'm not going to take time today to talk about how judges or prosecutors can be sued under Bivens, but they can. Very high burden because of the idea of their absolute immunity for doing their jobs. But then there's qualified immunity. And what the case law has made clear is that it's an affirmative defense. And what that means is it has to be pled, and the burden initially to plead it and show it falls upon the person pursuing the claim. But once that defendant has met that burden, then meaning the officer has met that burden that the defense exists, then it goes back on the plaintiff pursuing the claim to show that the conduct involved amounts to a clear violation, a constitutional violation, and a clear violation of established law. You can go to the next slide. Now, the officer is immune from liability. And what that would mean under a qualified immunity doctrine is that there has to be a fair and clear warning to the officer that his or her conduct violated the Constitution. You see that as a limitation in a lot of these cases. The courts also look for prior examples of cases to see whether or not there's what they call obvious clarity in how an officer or an agent could respond to a particular situation and know that their conduct was unlawful. And then you get into a reasonableness standard, which is dangerous. Again, very pro to defendant, very hard for the person that is bringing the claim to show, which is that there has to be this conduct clear to a reasonable officer that the conduct, his or her conduct, was unlawful in the situation that was confronted. Now, we usually see this progression of how the fight over qualified immunity occurs, starting with often motions to dismiss under Rule 12B. They then are asserted as an affirmative defense, particularly in response to judgments on the pleading type motions under 12C, but mostly they get fought out in the context of summary judgment. And I do want to go back to the prior slide for a moment. Just there's a case that's worth looking at in the 11th Circuit. It's this Lanier City, Patel versus Lanier City case, because it had both a yin and a yang to it. The court found some qualified immunity to apply. That was bad for the plaintiff, but some not to apply. And in that instance, they talked about the hazy border between excessive and acceptable force. Not the kind of standard that I'm comfortable with, candidly, when I see, obvious examples of what seem to be misuse of force by police. Okay, go to the next slide. So qualified immunity, basically there's a history to it. There's a justification for it. Next slide. This is to emphasize that you have to prove a violation of a constitutional right. Callahan talked a lot about that. And then go ahead to the next slide. You have to establish that there was a fair warning that the conduct was unconstitutional. Okay, then in the slide deck, you're going to see concepts of absolute immunity. And this applies to both judges and to prosecutors and also to public defenders. And I have been involved in defending a public defender in the context of these kinds of cases. Bottom line is that it goes to what the function of the job is, not to the title of the person. And if it applies, it's all encompassing. So qualified immunity protects public officials from personal liability as long as they don't clearly violate established law. But in some instances, judges, prosecutors, public defenders can be protected as long as they do not act in clear absence of all jurisdiction. Okay, so these are a lot of concepts. Again, this is a middle level conference webinar. I don't want to make it too basic or dig too deep, but the bottom line is to know who you're suing, to know why you're suing them, to figure out why the conduct involved doesn't get barred, and how you'll survive ultimately the motions, and particularly the motion for summary judgment. But I'm really the setup man here, and I have one sort of final comment to give you, but the guy that's the real deal and who can talk at length and forever because of the length of cases that he's had and the great job he's done is Phil Kaplan, who's coming up next. But I want to go back to that Mesa versus Hernandez case, because this shows just how daunting in Hernandez versus Mesa the facts can be. Because here we have a situation where some kids are running back and forth across the border playing a game. And an officer, for whatever reason was in his mind, fires his weapon. And under no stretch of the imagination in my world is that conduct acceptable. And the case went all the way up to the Supreme Court. But the Supreme Court, finding reasons not to expand Bivens, ultimately ruled against the plaintiff. And that just reminds you that these are serious issues that need to be developed. The harder you can work on the facts at the level of the initial claim and litigation, the better chance you have of winning or at least surviving through a course of litigation that in some instances, as in the Hernandez versus Mesa case, ended up at the Supreme Court. And there, again, I don't defend that result. But let me stop, because I think Phil's got a lot to say, and I didn't want to intrude on what is a little more meaty piece of this conversation.
Thank you, Michael. Very interesting. I mean, I just point out Hernandez v. Mesa is actually even worse than what Michael was saying, because the Supreme Court actually had to assume that it was an intentional shooting in order for them to dismiss the case, because there was a summary judgment. They had to they basically had to assume the best facts for the plaintiff. So even if it was an intentional shooting across the border, they said there's no relief at all, and the family basically got nothing. So, okay, here comes the real deal. Take it away, Philip. Thanks.
Thanks. I'm going to jump around. I'm not going to follow a PowerPoint, but I think the PowerPoint that Mike presented is really good stuff. So go through that when you've got the time. I'm going to hit some different areas, but I think before I start, I think Trina would agree with me that based on the Ziegler case and other authorities and what we know about the Supreme Court now and their feeling about Bivens is that I don't want to present this as Bivens is a great avenue for you all to pursue. Would you agree with that, Trina? So that's unfortunate, but I'm here to talk about it because I don't want to just discount it, because there might be a situation where Trina is really unable to assist that client because there's a problem with timing. So let's talk about the statute of limitations. So with Trina's presentation, you learned that there's a 2-year statute of limitations in the FTCA. So what's the statute of limitations in Bivens? The statute really, it's defined by 1983, section 1983. And how does 1983 do that? It doesn't have a statute, it doesn't have a term within the statute, but it looks to the forum, the state that's involved. So for example, I practice in Louisiana. The first question I ask a client is not what happened. I ask, when did this happen? Because we have a 1-year prescription. They call it prescription down in Louisiana. And invariably, something happened a couple of days ago last year, and I've got a few days to draft up a complaint. So your first question, I think it's a good habit, is ask your client when something happened before you ask them what happened. They want to tell you what happened, but ask them when it happened, because if it was more than 2 years ago, the good news in the state of Florida is, what is your statute for personal injury? 4 years. So there might be a situation where, even though Bivens is an uphill climb, admittedly, you may have a situation where your client's only resort is to get into federal court with a Bivens claim. So go for it. So once you do that, let's talk about your pleading. You can plead punitive damages. You can't do that in an FTCA claim. FTCA is against the government. There's immunities for punitive damages, but you're suing only individuals in a Bivens case. So understand that. You're not suing the Department of this or the US government. You're suing individuals, which means that you can sue them for punitive damages, and it can create a lot of leverage. As I explained to you before, when I had a judge tell these 2 police captains, hey, you're looking at punitive damages, your house could be taken, blah, blah, blah. So that's a lot of leverage that you do not have in an FTCA complaint, because when you start getting individuals worried, because by the way, most of the time they're not worried, they don't care, they get indemnified, they're fine. That's why you have some pretty bad behavior, because they don't have to pay. But when you sue for punitive damages, that changes the calculus. In your complaint, based on Iqbal, you want to plead the facts that support your punitive damages. Don't do the conclusory allegation. It's a waste of time. You're just going to get a 12B6 motion, and you're going to be bogged down in court for a bunch of, for a couple of months, and you're going to be in, 12B6 hell. So draft up a good complaint and really put the facts in your complaint about punitive damages. Request a jury. You can't get a jury in FTCA cases. Request a jury, and in your civil cover sheet, don't just, you check the box, but that's not good enough. Check the local rules. You need to put it in your pleading. Request a jury, and if you amend your complaint, request the jury again. If you don't do that, you lose your right to a jury. So stuff like that. So the other thing is, you're talking about qualified immunity. This is where usually the big battle is. And in my pleading, I try to preempt this stuff and plead with particularity why there is no qualified immunity. I even have a heading. I say, no qualified immunity, and boom, hit it right there in your complaint. You still might get a 12B6 motion, but at least, you know, the court's supposed to look at the four corners of your complaint. And at least you could say, hey, I've got all the facts here. There are allegations that mean that the court should deny that motion. But it's a way in which you are educating the court about the case. You're also educating the court about yourself as a lawyer, and that means a lot to the judge and to the judge's law clerk that are looking at a 12B6 motion. Qualified immunity. I told you before that I'm up on appeal with the Fifth Circuit, an interlocutory appeal. Why can, after I won that summary judgment motion, why were they able to go up to the Fifth Circuit and deny me the right to go to trial? Well, there's a reason for that. It's called the collateral order doctrine, because qualified immunity is not just an immunity from liability, it's an immunity from suit. So the idea is that they should not have to go to trial. They should be able to go up on appeal. So the issue there is going to be clearly established law. Mike was talking to you about that. The issue is, were the officers put on notice based on previous law in their circuit or in their district about their behavior that would have told them that it was unconstitutional? In my case, this Iraqi war vet, the officers arrived. The whole idea was that he was trying to get transported to a mental hospital, and so he lifted up his shirt, wanted to show them that he didn't have a gun, did 360, and then they bull rushed him, they tased him, and then they beat him. And the big issue there is de-escalation. So I said, look, there's law in this circuit on de-escalation. They should have de-escalated the situation and shouldn't have tased him. They tased him for an extended period of time. So then what's the argument going to be on appeal is, well, yeah, there was cases about de-escalation, but we don't have a case where the guy did 360. There's a case where a guy was on the ground and he had his palms up. So it's different. So it's gotten kind of crazy with all this stuff. And really what I think is going on is that some of the courts are finding a way to get out of it and deny plaintiffs the right to pursue certain claims. So the court just doesn't hate Bivens. The court hates people who may recover under Bivens. But put a cherry on top of this little presentation. Trina is very familiar with the Ziegler case. She argued the case and worked on an amicus brief, right, Trina, for the Ninth Circuit case, which is called Bull v. Eckbert. The site is 998 F 3rd 370. The cases are really interesting.
I would be remiss to take credit for arguing it. My co-amicus counsel, Matt Adams, did argue part of that.
You were there. So this case is a really interesting case. And what's interesting is that they're trying to expand this into the First Amendment. You heard Mike tell you about what are the three amendments that are recognized under Bivens. So it's Fourth, that was the Bivens case. Then there's a Fifth, that was, I think, a gender discrimination case. The Eighth Amendment, cruel and unusual punishment. So those are the recognized areas. Not first, but this Ninth Circuit case has a free speech retaliation component to it. Very interesting set of facts. A guy living in the state of Washington operated a bed and breakfast called this, it was affectionately known as the Smuggler's Inn. A guy from Turkey flew into New York and then flew out to Washington, was staying at the inn, and then a patrol agent came over. There was an altercation in the driveway of the Smuggler's Inn, and the owner of the inn claims that he was physically injured. He also complained to the supervisor of this border agent, and then what did they do? They contacted the IRS and he got audited. So then that's a free speech retaliation claim, right? I'm criticizing the actions of the officer, and then look what they do. They sick the IRS on me. So what does the Ninth Circuit do? They said, well, I think there's a slight extension of Bivens, and we don't see any special factors. We don't see a problem here. So this is up with the Supreme Court right now. And Trina, have you read the transcript of the oral argument? You have?
Yeah, I listened to it.
Okay. Okay. So this is a little section that I'm going to call you too could be a Supreme Court justice. That's to all of you. So this is Justice Barrett, who is questioning the attorney for the proprietor of Smuggler's Inn. Justice Barrett, Miss Ellsworth, what if this had happened? You know, Smuggler's Inn was very, very close to the border. What if this exact same encounter at which Bull alleges there was excessive force had happened not on his property, but right next to the border? What then, Miss Ellsworth? So as a factual matter, his property is right next to the border. Justice Barrett, he's next to the border? Okay. Miss Ellsworth, it's about 10 feet away. Justice Barrett, but like, what if we push it up like right by the border? It's not his driveway, it's right by the border. Does that change things for you? Miss Ellsworth, I don't think it does, Your Honor. I really don't, because the conduct that the agent was engaged in here was ordinary law enforcement conduct. He was following up on a tip given to him by Mr. Bull to come and inquire about this or talk to this Turkish guest. And once he followed up on that tip, if you look at Joint Appendix 108, the agent left. There was no further concern, no further sort of exigency at the moment. So I don't think the proximity to the border makes a difference. So interesting there, because you're hearing the theory of the proprietor, and but it's interesting that if you were trying a case, Mike, you know what this is like, and you ask a question like that, this is sort of your pants at your ankles moment. So this doesn't, yeah, this is there's nothing wrong with having a justice on the Supreme Court who's actually been a trial lawyer and has some experience with representing real people. So, but I thought that was an interesting. But the whole oral argument is really interesting. So I recommend it to all of you. I think the Supreme Court's going to do some interesting things with this. We might get a few surprises. But I don't think they're gonna recognize, Trina, a First Amendment right. Do you? I don't think they will.
Yeah, and I don't think that there was a very vigorous defense. The whole argument really doesn't talk about the First Amendment claim. It's super focused on the Fourth Amendment claim. But I think the passage you just read brings up an interesting issue that relates to what Mike was talking about in the facts of the Hernandez case and the Rodriguez case, which was also a cross-border shooting. The court was very, very concerned about the extraterritoriality component of the Bivens claim, and was really, really concerned in those shooting cases about what Mexico was how they were going to react. And similarly, you heard Gorsuch and Barrett ask questions about Canada at the argument.
Yeah. Yeah. It's also interesting, if you read the Ninth Circuit opinion, the first sentence for the facts is, and we all know how important this is, it said, Bull is a United States citizen. That's how it starts. So I think we're going to get an opinion from the Supreme Court that's going to recognize this. But in oral argument, the lawyer said, no, I don't think this is an extension of Bivens. I don't see any difference between a border agent and an FBI agent. So the Ninth Circuit felt it was a slight extension, but there weren't any special factors that caused any concern. But I don't think the Supreme Court's going to recognize a First Amendment avenue to pursue under Bivens. So we'll see what happens.
If I could just jump in, yeah, just to echo what Phil was saying and Trina just now, and again, this is the drum that I beat. There's a lot of judges at the district court level who have been trial lawyers. That's your best audience. It gets worse as you move up the chain of potential appeals. So the time to make your facts, like Phil said, is in the complaint, and then drive those facts home in the records you make at the district court level, where you might actually get someone who understands why those facts matter, because it's going to trail all the way up against a river that's flowing the wrong direction right now.
Okay, I mean, when I first heard about this case, Egbert v. Brull, I mean, it really sounds like there's no chance whatsoever. I mean, we've got a super conservative court. We've got 40 years where the court has not, ruled a single time in favor of the plaintiffs in a Bivens case. I mean, they did it 3 times, and then for 40 years they've denied 11 cases in a row. And then this one, you got like Phil said, you got the smugglers in, and that's just not a good fact. He's got, apparently the guy had on his license plate, they came out, because I listened to the Supreme Court oral argument, it said his license plate said smuggler on it. So, it just, the facts didn't seem good, and it's the Ninth Circuit, and clearly the Supreme Court doesn't like anything involving, like you all said, I mean, they don't like anything new, but least of all, they don't like things involving the border and national security and anything like that. But then when I listened to the oral argument, I actually came out the other way, because I felt like the lawyer did a really good job of showing that it really was not a new context. I mean, this is the center of Bivens is the Fourth Amendment. I mean, obviously the First Amendment claim is not going anywhere, but the Fourth Amendment claim is exactly the heart of Bivens. And the lawyer was saying, well, what's the difference? Just because we're near the border, this is an American citizen, and they were investigating, sure, they were investigating an alien, but the alien was actually going to Canada. He wasn't coming in. So where is the national security? Where is all these special factors that they always talk about? So it's really the heart of Bivens, which is the Fourth Amendment, that they came onto his property and refused to leave. And so, I mean, I'm kind of a little bit optimistic here.
I think they're going to affirm in part the Ninth Circuit, but not on the First Amendment. I think that's what's going to happen. I
It would be the first time in 40 years.
Yeah, I think that actually will happen, because but then they're going to use that as an opportunity to really, explain their position. So yeah, I think that's what might happen. It was interesting. Clarence Thomas's first question was, out of the box, was a pretty tough question for opposing counsel.
Yeah.
Yeah.
And then
I would
like
say that if people are listening to this and thinking about Bivens claims, which Phil, I think it's really great you were talking about the statute of limitations. If it were me, and if the statute of limitations is not going to run until after June, I would wait to see what happens in this case before filing the complaint, because I think it'll help inform, potentially help inform how you're going to style things and frame the complaint. I mean, obviously file if your statute of limitations is going to run, but we're going to get a decision by the end of the Supreme Court term. So it's
always file.
And it's such a dramatic case that, if it comes out our way, then that's good. But if it comes out the other way, it kind of eliminates Bivens for anything involving, the border, immigration. So let's hope here. I like the way the Justice Breyer, I don't know if you heard that, but I guess he was arguing, are we down to, because they're saying it has to involve the same basic facts as the original Bivens case. So he's like, does it matter if it was a Tuesday or a Wednesday, or so hopefully we're not going to get down to.
I know, that was good.
Breyer, yeah, wait, who is this guy? Is he still a Supreme Court justice? I get very confused.
Yeah.
Hey, by the way, just a little, I was a substitute teacher. Mike went to Georgetown undergrad, right?
Yes.
So I was a substitute teacher at Georgetown Day School, and that came up in the confirmation hearings with our Supreme Court nominee, because she's on the board of directors of that school, and they talked about the books and all that stuff. So yeah, I was a substitute teacher before I went to law school at Georgetown Day School, and we had the way it worked is you were not to be called by your last name; it was first names only. So you know how liberals are. So that's what we did.
Well, Phil, let's hope that you being there doesn't disqualify our justice.
Okay, we actually don't have more questions. So let's just keep talking a little bit. I know Trina, you just they just mentioned that you were involved in I did with the Abbasi case or one like it. I mean, that's also a super interesting case in the sense that, well, we had a bunch of people who were just held for months simply because they were Muslims and no other reason whatsoever. They hadn't committed any crimes. And then the Supreme Court said, yeah, there's no remedy whatsoever. Maybe you could talk about that.
Sure. Abbasi was the post 9/11 reaction where the FBI and the government rounded up a bunch of Muslim American, people of Muslim or Southeast Asian descent, and held them in some really horrific conditions in New York and New Jersey. And that case sort of comes up and becomes the new context test for Bivens, right? That's the thing that, Hernandez and Boulay now are looking at, that test that was announced. But the piece about Abbasi that doesn't get a lot of attention is that there were some FTCA claims in that case as well. And, so that's something to keep in mind. But then there was a detention condition claim that the court actually sent back down to the district court and said that wasn't necessarily a new context. I'm not remembering exactly, but the component of Abbasi that is a recognized Bivens claim, I think it was the Eighth Amendment claim, went back down. It wasn't decided. They said the district court needs to apply the special factors test that we've just announced.
Mm-hmm.
So that's something worth noting. Yeah.
Okay. I have an idea. I don't know if this is going to work, but Phil, no, I'm sorry, Michael, you're defending the qualified immunity, and I can see there's a point to it, right? Because officers want to feel that they're not at risk for everything they, for every time they do something wrong. I'm wondering if you could defend it, and maybe Philip could, or somebody could give our side of it. Well, why do we have this qualified immunity? And what I think is interesting is, what I heard is that the court is always attacking Bivens because they say it's a court-made remedy, and then it turns out that qualified immunity is completely court-made also. And
Yeah,
they don't seem to have a problem with that.
I think we unpack the history of it, and it may well be that stare decisis is long gone, and that we really are now sort of victims of the moment, because certainly the way we have seen police conduct, agent conduct, and the way that I think the public generally feels about it, and this whole fight over Blue Lives Matter and how we react to all the controversies, it means we're in a different age, and the idea originally behind qualified immunity was to actually allow well-meaning officers to do their job. Sometimes in the context of street police, you hear the idea, and citizens advocated, that we don't want our officer hesitating to fire that weapon when it could ultimately mean a good person dies or even an officer dies. And it's that fear of hesitation, that fear of impeding on the job of good thinking, well-minded agents and officers. I think that led to this doctrine. They don't have the money to defend themselves. We don't want them impaired in their job. We want them doing their job. The problem is it starts with the presumption of good and well-minded officers. And I think that presumption is now certainly more at risk today. Phil, what do you think?
Well, yeah, it's a complex area because there's also an issue about governmental overreach and governmental power, and libertarians have a concern about true libertarians. I mean, I sometimes hear about libertarians, right? They're not very honest, I think, but there are some true libertarians. And I had a judge on the Fifth Circuit, and I got a reversal. I looked at my panel. I thought it was fairly conservative, and there's a new addition. This is a true libertarian. He was the one who took the most interest in my case. It was a 1983 case, and I got it reversed, and we went back down. what does Clarence Thomas think about going back to Ziegler case? I mean, it seemed like he was very interested in it, and maybe concerned about the governmental power, and maybe wasn't very impressed about how the government sicked the IRS on this plaintiff. I don't think it was very impressive, and so I think that there are some judges who don't like that. So yeah, I think sometimes they back the play of police officers, don't want to second guess them. But I think that there are also concerns about governmental abuse and the abuse of power.
Yeah, and I think, you know, what we end up seeing is that we're likely not going to undo qualified immunity, but you can attack the conduct on the reasonableness grounds, on the clear violation grounds, and try to build a factual record to defeat summary judgment, to at least get you in the door. But then we run against what Phil had mentioned, this issue of interlocutory appeals, and how, you know, you can still be stymied and never get to your trial while the case goes up.
Yeah, one thing I do think I do see is, seems like when it comes to clearly established law and the analysis, it can be a little bit different when it comes to excessive force cases versus denial of medical care. So I think we saw a more lenient view in that case you had in your deck.
The 11th Circuit case, yeah.
11th Circuit case, yeah, and I actually looked at a district court case after that. And they said, look, it should have been obvious it was obvious to a layperson that that this was somebody who was in need of medical care. And so I think they're going to be more generous. So I think for the practitioners out there, if you have a case involving the duty to protect in terms of medical care, I think you may have a better chance than maybe in the excessive force area, especially if it's a deadly force area. That's where things really tighten up. So I do see some differences there.
Can I ask a question, since we don't have questions in the chat? We have Phil and Mike on this panel. One thing happens in the excessive force context, particularly when there's excessive force in a detention facility or a prison. What we have seen is the government will then charge the detainee with some type of aggressive act and say that the guard was just protecting himself or herself, and put the person in disciplinary proceedings, and leaving that person sort of fight the disciplinary proceedings within the prison context. You know, as a criminal defense, you know, as people relate to the civil rights, what is your experience with those disciplinary proceedings? Are you able to get in and represent the client at that stage? What if that didn't happen? You know, what do you advise, you know, your clients in that situation? Because I think it comes up for a lot of immigration folks, and they're going to want to know, should they be getting lawyers for the disciplinary proceeding for their client, or should they be jumping in and trying to do that?
Okay, Mike.
Well, I think the answer is yes and yes, but here's the thing that bothers me the most. The system allows it to be manipulated. And unfortunately, you know, the best defense is a good offense is too often the case. So I think we see more and more attempts to head off a Bivens type claim by going after and blaming the victim. That said, I think it shows the importance of either, you know, getting that person represented, or at least getting in yourself. But it ain't easy, and often information comes out after the fact. And many of these people, God bless them, don't understand what's going on with them. They don't know enough to get someone to help them until sometimes it's too late. It might be a language issue. It might be fear, particularly in the immigrant context. I know at Chrome, we have a lot of issues. So I think it's a great question. I don't think there's an easy answer, but, you know, I think we have to try to get these people represented.
Okay, I just got a question here. It says, is there any federal court decision that addresses this conflict that qualified immunity is court created, just like Bivens, and actually explains why one is expansive and the other not?
I mean, the quick answer is I haven't seen that issue brought. It's a great issue. We don't seem to see a discussion of it in the cases I've read.
Okay. But I'm getting some more questions here. Okay, I guess we'll just open up to everything now, not just Bivens. Does the Leo's record, professional record, come into play in these cases? For example, if they have a record of discipline for excessive force or Fourth Amendment violations?
I mean, I'll give a quick answer, but then segue to either Trina, Jennifer, or Phil. On the issue of the reasonableness of what the officer believed, a prior record should matter, especially if they've been disciplined, so they know the conduct is not within proper grounds. But that's my quick reaction. That's the reaction I would have if I was dealing with trying to defend such an officer.
Okay, I mean, my case was I didn't do the Bivens route whatsoever. I just decided right away mine was an FTCA, and there was no point in going after Bivens because, as you guys said, I mean, it's all one. There's going to be one relief in the end, and I didn't see the point of it. But I know in my case, the guard that had raped my client had some, had been discharged dishonorably from the military, and that was a big factor in my case.
But it is hard.
And I mean, there was more behind that. Okay, sorry.
Well, and Mike knows this. I mean, they're going to have a prior bad acts defense unless there's a pattern. But it may be relevant if this was somebody who's not supervised. But before you even get to the relevance or before you get to the admissibility, let's talk about obtainability of
right.
So I would recommend the practitioners out there is don't wait to get your discovery out. If you want to get somebody's jacket, you're going to have to fight for it. They're not going to turn it over. You're going to have a protective order, but on top of that, they're not going to turn over disciplinary stuff. They're going to raise the official information privilege, all kinds of privileges and all kinds of stuff. So they're not going to turn it over to you. You're going to have to fight for it. So most likely you're going to be filing a motion to compel or something like that to get that stuff. Then the next hurdle is whether it's going to be admissible. But you're going to have to argue admissibility and relevance in your motion to compel because you're going to have to argue why I want this stuff. So be prepared for that. But get your discovery.
And the good news there, I'm sorry, Phil, is what you said before. It gives you a chance to educate the court. These are early opportunities to try to get your facts out there in a way that might help you down the road. So, even though it's sometimes nearly impossible to get your hands on the records, that motion to compel may be a vehicle to get, some steps ahead with the judge.
No, every time you're before the court, you're trying your case. So if you don't realize that, you're not doing it right. So if somebody else, the defendant files a 12B6 motion. So rather than looking at that as, oh crap, I gotta file an opposition, use that as an opportunity to sell your case. They have now given you an opportunity to tell the court who you are and what this case is about. Use it as an opportunity. They gave you the door, go through it, go through the open door.
And one other thing, I'm sorry, I was just going to add to the overall context of suing is typically we're not talking about just one agent or officer. And that's where these conflict issues on the government side can arise because you might have 3, 4, or 5 agents and they may have different defenses in terms of their conduct or what was reasonable or what they thought. So don't lose sight of that fact either when you're suing. It's not one size fits all, and you may end up sustaining your case against some people, but not others.
And can I make 2 practical points though on this record and what happened, right? It's not just the officer's prior record, but oftentimes in these abuse cases, there's a video that is out there. And so there's 2 things I sort of recommend to people. One is file a preservation letter, right? You can put the agency on notice that you might be filing something and that they should preserve all evidence related to that. And 2 is don't forget about FOIA. We have some FOIAs going on these abuse claims where we're trying to get the evidence and the video before we file the FTCA claim, because when you're negotiating an FTCA claim, you really want to know what the video looks like. otherwise, at the admin stage, you're just talking to a government attorney who's probably seen the video and you haven't. And you can file a FOIA request for that video or for those records about the investigation, get before a federal judge. And that, let me tell you, is putting the agency on notice that you are coming with a liability claim. So I think that improves your position, at least in negotiating in the FTCA context and negotiating in the context at all. You want that information, so don't forget about FOIA.
Yeah, and I was just gonna.
Okay.
I was just going to add one thing about FOIA, which is don't just FOIA one agency, any agency that touched it, because we get all kinds of different things. We do a lot of FOIAing at every stage, and you know, for instance, there are critical I-213s, and in my case, there's like 5 different versions of them, and they're so different. It's like somebody just went in and edited them whenever they wanted to, and that's not the way it's supposed to work. So I mean, it's really, if USCIS touched it, whoever, if CBP touched it, make sure, because it's really incredible. Like, you're still going to not get what you think you should unless you fight it and actually litigate the FOIA, but you can get some incredible stuff.
Yeah. Good.
And I was just going to add, you know, as we be creative, it's important to be creative in these complaints. And we are in a video age. It's the case that Philip mentioned, where, you know, you had, you know, or at the beginning, you know, where you know, Robert did with a camera, where you may actually have some video or photographic evidence before you have to chase to get more of it. And I'm wondering, you know, now we can include some of that in our complaints, right? Make the complaint come alive. You know, whether it's, you know, like in the body of the complaint, putting photographs, but being creative. It's something that at least impacts me when I see it.
Okay, I'm going to go on more questions here. I just looked at some random FTCA settlements. The largest ones seem to be against the VA. If VA claims are generally much larger, why is that? Because they're Americans? No.
No. You know, I mean, I think that's not a facetious answer. It's also Americans who have served. I mean, it's terrible to think that there's that distinction between who deserves more money or who doesn't. But I think you could see that being the reason.
And I think people are interested in the settlement amounts, is like, at least for the FTCA, it's paid out of the judgment fund. And you can go online and you can see payouts to different agencies. I think there's sometimes a brief description of what the claim is involved, and you can get a sense of what the payout amounts have been historically.
Okay, I'm thinking this is mostly for immigration people. How would you overcome the client's apprehension to file any type of claim against the government for fear of retaliation when they have pending applications for relief?
So I have a couple of responses to that, but I also have experience with that where there was retaliation. So I don't want to say that like it's not at all possible to happen, but you know, here's what I would say, right? Like, it's totally going to be the client's decision. Usually you're talking about, you know, agency counsel on the abuse claim. It's like the left hand and the right hand aren't communicating with respect to what the application is that's out there pending. You can bring that claim and you can try to use that as leverage for what you want to happen in the application case. If you're trying to get, you know, that's why the FTCA is the United States, right? But if you're suing ICE and there's some relief that ICE can give, you can engage in a conversation about that. If you're suing ICE and you need relief from CBP, you know, you're dependent on ICE trying to ask CBP for that form of relief. But applications are generally pending with USCIS, which is just sort of, you know, out there. So I tell clients it's possible, but, you know, it shouldn't happen. And if it did happen, right, and there's a way to prove it, you know, there's a way to try to sue about it. I will say that at the admin stage, it's unlikely to happen. It's less likely. And so you can also assure the client that you're just doing this at the admin stage, and then you can decide whether or not you're going to go to federal court later. It's not a reason not to do an admin claim. And then at the district court stage, like we all know, and especially with non-citizens, you want a protective order. You want language in the protective order saying that, you know, it's attorney's eyes only. You want to screen that information, you know, anything that's damaging. But at least with non-citizens, you have to sort of, when you're thinking about engaging in a federal court action with somebody who's undocumented or has undocumented family, you've got to advise them of the risk of being brought in for a deposition or, initial disclosures that are going to relay information about their family. You ethically have to
Okay,
do that,
Trina,
but you can try
that
to
was
contain it with a protective order.
that was a tease. What was the retaliation? I'm just curious. I mean, because I've never seen that. So what kind of retaliation did you see?
Sure, we had a U.S. citizen who was detained in Southern California for 7 months, and all her brothers and sisters were U.S. citizens. Her mom was a U.S. citizen. She kept telling the officer she was a U.S. citizen, and then after 7 months, it came to fruition that she was a U.S. citizen, and then she got released. She wanted to sue, so we filed an FTCA claim, and then after filing that claim, the agency sought to revoke her naturalization, and then said they were going to go after her mother and her brothers and sisters. And so, we were in mediation, and I'll never forget the magistrate judge who was sort of delivering this said, I've never seen anything like this. But the client settled for, I think, less money than she was entitled to, because we worked out a forbearance that they wouldn't go after her mother and her brothers and sisters, to try to denaturalize the mom, which would have denaturalized the kids.
So Trina, when did this happen? Hopefully it was within 4 years. I like it's a right to petition claim. I think it's a free speech retaliation First Amendment case. I like it. That's a big one. Hopefully it was within the past 4 years.
I think it was longer than 4 years, but I will check and get back to you if not.
Let's see what happens with our Supreme Court case. You never know. They might surprise us. I don't know if they're going to surprise us about the First Amendment. Hold on one second. I got to get this call.
Okay. Well, what else? Does anyone have any thoughts about bringing in the media to a case the way I did? I mean, I kind of did it because I felt like I didn't have much choice. They were about to deport my client who had just been raped, and then they were going to get rid of, wash their hands of the whole problem. So it worked, though. I mean, they then arrested the guard. I don't think anything would have happened otherwise.
I think it depends a lot on the client, right? Because it could be re-traumatizing and even dangerous depending on the case and the client. I know I come from, I have done a lot of defense as well as plaintiff work over the years, so I'm always a little bit wary of the press. But I do think that there has been some feeling that press around the family separation cases may have endangered some people. And I know that some of the immigrants that I've worked with, having people approach them, it would be a little much right now. So on the other hand, I have it's obviously can be very, very effective, especially if you get the right reporter. So I view it as sort of a double-edged sword.
Okay, Trina, you talked about getting immigration relief. Can you talk about when that's actually worked? I mean, has it happened?
Yeah, it has happened. There was some folks.
Don't you have a great advisory on that?
Yeah, I think there's an advisory out there.
It's really good. Yeah.
That talks about that. I mean, some of the forms of relief that I'm aware that have come through the FTCA settlement or at the admin stage or later include things like getting deferred deferred departure, getting parole, sometimes an EAD.
U visa sounds like a great option.
Vacated an expedited removal and a reinstatement order.
Okay, but you've been able to get those things?
Yeah, I mean, hard fought things, but yeah.
I mean, basically, if your AUSA or whoever you're dealing with is willing to go there, I mean, you basically have to get the people in immigration court on board, but a lot of times they will. I think the harder person to convince is sometimes the person that you're litigating with, because they're not used to that. But it can be done. But I agree, it's technical and it's challenging.
Yeah, I mean,
no, they shut me down in my case. I mean, they just know.
I mean, that's what I think the benefit is to reaching out to agency counsel at the admin stage. I mean, that is the point where they may be willing to explore what you're asking for. We were asking recently in a case involving a wrongful deportation for them to grant or to rescind a smuggling allegation, because that would have allowed the person to pursue relief. And that's all we were asking CBP for. And but then relief got granted and the person won another form of relief. So we took that off the table. But, those are the kinds of things that you have to think, okay, what agency am I dealing with and what might they be able to give me? And then make that ask. There is absolutely no harm in asking.
Okay. What about, just a general question, maybe for Phil, but do you prefer a judge or a jury if you get a choice? I mean, I know Bivens is juries and FTCA is judges. Is there a preference, one or the other? I'm thinking in South Florida, a jury would be a good thing, but I've never gone down that route.
Yeah, it's not a one size fits all situation. You've got to look at the jury pools in different district courts. You got to look at the type of case. You got to really look long and hard at your client and how that person's going to play in front of a judge versus a jury. I had a jury case in New Orleans in December. Afterwards, I thought maybe should I have gone to the judge, but it's not a one size fits all. You got to really look at every particular case and really look closely at the jury pool and do an analysis of whether you think that's going to play better before a judge. So I think sometimes a lot of time it depends upon your legal theory. If it's pretty complicated, maybe you want to present that to a judge. But if it's not so complex, take it to a jury. But if it's kind of complicated, and constitutional law stuff can be really complex. Our jury instructions were I don't know, 50 pages long. And it was difficult for the jury to try to follow all that stuff. So you got to think about the theory of your case and whether it's really complicated and whether it's just going to be a pain in the rear end for the jury to try to follow some of the law.
But, the reminder here is, you ask for it in your complaint. You can waive it later. And what you'll know by the time you get to that choice is how you view the judge. Because if you're there, that means the judge has denied the motion to dismiss, denied the summary judgment. You may have, and Phil's point about it being a complicated issue is one decisional fact. You may have reasons that you trust the judge. Most of the time, we tend to want juries because we think the awards will be higher. But juries surprise us and disappoint us too often. So it's a tough decision.
Okay, thank you. We're getting to our closing. If everybody just wants to go around really quickly and just state, do you like this kind of work? Is it personally satisfying? Do you have any recommendations for people that are thinking about putting their feet in the water? Trina?
So yes, immigration attorneys add this tool to your toolbox. I think that there are ways to strategize to use it as a holistic approach to your practice. I'm a huge fan. I hope you'll take advantage of the resources that we have on our website and our strategic assistance program so that we can help you do this work if you're new to it. Thank you.
Jennifer?
I think that the FTCA is incredibly both satisfying and challenging, and because of you have the ability to, before the case, to look at the state where it happened, find out what the elements of the tort claim are, and then find out if there are analogous things that are similar. Look at the other defenses. Before you file, if you look at all the defenses that are in the PowerPoint that I've provided, what your chances are. And it's an incredible way to get relief. And I prefer myself having the United States, all of the United States on the other side, not just because they have the money, but there's really, in terms of discovery, there's nothing that they don't have the ability to produce after a fight. My experience with Bivens is there are so few things that it applies to, and it's good if it applies, but it's really just a couple, like I think we said, 3 amendments or something. And the way that qualified immunity, it has to be like for basically in those jurisdictions where the constitutional, where unconstitutional conduct defeats the discretionary exception, you're in a much actually a much better place there. So, because you can just have something that's recently been held unconstitutional, and it can be very, very effective, where the whole thing in Bivens is it has to be well established. You need almost a case on point. It's horrible. The only time that you don't need like a case almost on point is if it's there. What's the recent case where the guy was in the cell and, I mean, they recognized this without, even though there wasn't a case on point. And there's like, he was up to his elbows in feces. And, I mean, it has to be so extreme. So yeah, I mean, if you can find a case on point, it's really hard to do that. So I really like the FTCA better than Bivens myself for a number of reasons, but winnability being key.
Michael?
Yeah, I mean, look, this is important work. And it's an area where you're actually helping people. And, for that reason alone, I urge people, to get into it, to try to, do the right thing, and also to help shape a law that, maybe needs to be better shaped. So, I think these cases are so important. I couldn't say it strongly enough.
Okay, Philip.
The reason I do this stuff is I saw To Kill a Mockingbird. So I said, that's what I want to do. And then somebody pointed out that the lawyer loses that case. You will, and by the way, if you fight a worthy battle, that's a battle that you can lose, but at least you did something good. So that's a nice thing to know about yourself, that you were willing to do that.
Okay, well, thank you very much to the panelists. You've now heard from the masters. I also want to thank the chairman of the committee, Mark Prada, and I want to thank Diana, who helped me put on the slides today. And I want to thank everybody for watching. We're going to be sending the all the PowerPoints and other information by email. Thank you very much, everybody. Go get the government.
Have a good day. Yes.
Thanks.
Be careful out there.
Bye, y'all.
Bye-bye.